Good morning. Welcome to The People's Voices Must Be Heard, updating the Electoral Count Act in 2022. I'm Jonathan Diaz, Senior Legal Counsel for Voting Rights at Campaign Legal Center, and I would like to thank you all for joining us. Campaign Legal Center, or CLC, is a national nonpartisan organization that works to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process and believe our democracy should be transparent, accountable, and inclusive. In the United States, the president and vice president are chosen by the Electoral College, which is composed of electors from each state. Congress then counts these votes from the electors to confirm the winner of the presidential election. A law known as the Electoral Count Act, or ECA, provides the primary legal framework governing this process. Today, our panel will discuss the history of the ECA, its implementation, and how we can update the over 130-year-old law to ensure that our elections are decided by voters and not partisan politicians. Our moderator for today, Paul Smith, is Vice President of Strategy and Litigation at Campaign Legal Center. He has 4 decades of litigation experience, including arguing before the U.S. Supreme Court 21 times, where he secured numerous victories in cases advancing civil liberties, including voting and civil rights. Now I'd like to welcome Paul to introduce the members of today's panel.
Thanks, Jonathan, and welcome everyone. Before I introduce today's panel, let me start with a few housekeeping items as usual. At the end of the discussion with the panel, we'll start the audience question and answer portion of the event here. And all questions for the panel can be submitted in the comment sections on YouTube, Facebook, or LinkedIn, however you're watching us today. We'll do our best to get to each question that gets submitted, but in the interest of time, we may not be able to do that. If we're unable to answer your question, you can submit it to us by email at info@campaignlegalcenter.org. Now let me introduce today's panel. First, Genevieve Nadeau serves as a counsel at Protect Democracy. She uses strategic litigation and policy advocacy to protect the rule of law and guard against democratic decline, with a recent focus on protecting free and fair elections. She also helps lead the policy network of the National Task Force on Election Crises. Thomas Berry is a research fellow at the Robert A. Levy Center for Constitutional Studies and managing editor of Cato Supreme Court Review at Cato Institute. He was previously an attorney at Pacific Legal Foundation and clerk for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. And Adav Noti is the vice president and legal director of CLC, where he oversees our programmatic activities. He has conducted dozens of constitutional cases in lower courts and the United States Supreme Court. Thanks to the members of the panel for joining us for what I'm sure will be an interesting conversation on an important topic. So let's jump right in and start with Adav, but I want everybody else to feel like they can weigh in on these questions too. During presidential years, Adav, we hear a lot about the Electoral College, but it's only recently that we started to hear about the Electoral Count Act. Can you kick off our discussion today by telling us more about what the Electoral Count Act is, its role in the process, and why it was passed in the first place?
Sure, thanks, Paul. So as Jonathan sort of touched on in his opening, right, in the United States, we don't actually vote directly for the President of the United States. The structure that the Constitution sets up is that the voters in the states vote for members of the Electoral College, and then those are the people who actually cast the votes that determine who the next president is. And the Constitution, although it sets out that procedure generally, has very little to say about how we get from Election Day, where the people cast their votes, to Inauguration Day, where we actually have a new president. It doesn't say very much about how those popular votes get turned into electoral votes. And for a long time, the whole system sort of operated by tradition. For the first 100 or so years of our nation's history, there was no particular spelled out framework for how that process all worked. The Electoral Count Act today is the law that governs that process of turning popular votes into electoral votes and determining who won the election. It was passed, and where it comes from is it was passed after the election of 1876, where there were tremendous disputes about who had won various states in the election, which presidential candidate had won. And those disputes carried over to the point where it became unclear whether we were going to have two people claiming to be president, or how we could even as a country, solve this dispute over who had won this election in 1876. And in the end, there was sort of a negotiated resolution with a bunch of backroom deals being cut, and it was very bad for the country. It was a dangerous situation, and the end result was not good for the country. So after that election, Congress passed this law, the Electoral Count Act, to provide a framework for how that process would work in the future, and particularly if there were any disputes about presidential elections, how they would be resolved. Now, it's called the Electoral Count Act of 1887 because that's when it was passed. And the reality is, other than like a couple of tweaks along the way, it's really the same law that we have today. So I think much of what we're going to talk about today, sort of the ways in which that law from 1887, based on the 1876 presidential election, is sort of not cutting it anymore in the modern presidential environment.
Great, Adav. Anybody else have anything to add on that? If not, let me just turn to Tommy Barry and say, now that we sort of all know what the Electoral Count Act is and what it's supposed to do, which is help us figure out who won the election and get to Inauguration Day, can you tell us why is it suddenly in 2022 an urgent problem that we fix the Electoral Count Act? What are the flaws in the law that you and others have identified?
Sure. Well, there are many, more than can be recounted in a 1-hour panel. But what got attention, obviously, was January 6th of last year, and specifically the procedures in the act for invalidating or tossing out a purported electoral vote. So this is by far the most controversial aspect of the count, is the notion is that the Electoral Count Act is based on the premise that part of counting means deciding whether papers received in Congress are legitimate, lawful, correct electoral votes, or are not, and should be tossed out and discounted for some reason. And there's mostly consensus that there should be some way to toss out hoaxes, pranks, or something else that's just blatantly illegal. But one of the biggest flaws is that the law is too vague about what is the standard for tossing out a vote. It uses general language. It says you can toss out a vote by a majority vote of both houses if it's not lawfully certified or regularly given. And it doesn't define those terms. Some on January 6th argued that that allows you to essentially relitigate the conduct of the general election, so that if you had an issue with how a recount was conducted in a state, or if you disagreed with some state Supreme Court decision on state law procedures, then it's up to Congress to overrule that and decide, no, I don't think this was truly lawful. And so one of the most important things is to spell out, what does that mean to be not regularly given, for example. In addition, the threshold for just debating whether to toss out a vote is extremely low. It just requires one member of the Senate and one member of the House to grind the whole process to a halt, separate, and debate for up to 2 hours. That, as we saw on January 6th, that leads to both slowing down the process and a lot of opportunities for chaos. And so there's been a lot of arguments to raise that threshold to something where it would only be triggered if there's some consensus that there's some legitimate issue at least worth debating. But I'll defer to other panelists to add on to those two basic ones.
Adav, Genevieve, you want to jump in with other things that you would point to that need to get fixed?
Sure, happy to jump in quickly. And I know we'll talk about this in a little bit more detail as we go on. But I think, sort of building on what Tommy said, one of the fundamental questions underlying the ECA is sort of what is the appropriate role of Congress versus the states versus the vice president as president of the Senate. And so there are really sort of built-in ambiguities there in the statute that we have learned the hard way really need to be addressed.
This is the Pence issue, among other things? Or
Among other things, yes.
how about you, Adav? You got something?
Yeah, I think a couple others, and like Tommy said, we could go on at some length about
Part of the problem is the law is virtually unintelligible on top of everything else, right?
Right, and one of the ways that's most problematic is in sort of when you get to the end of the process, and this thankfully did not happen in 2020 and has actually never happened, but it's sort of the nightmare scenario. You have a dispute about who won an election, it gets to Congress, and then Congress can't resolve it, right? What happens if Congress deadlocks on the result of that dispute? Who makes the decision? I mean, at some point we have to have a president. We can't have two people claiming to be president. So who makes that decision? The Electoral Count Act, although it attempts to resolve that question, it does it in a very unsatisfactory way that I think we'll talk about later, in a way that's not even clear would really work in practice. And so that's one of the problems, that going into the process, you don't know how a deadlock would be resolved. The other that I think is worth mentioning is actually on the front end of the process, way before we get to Congress, which is that the existing act tries to prioritize or incentivize state resolution of disputes over presidential elections, right? It tries to provide a way that states can determine who won their own presidential elections and then have Congress just respect that rather than second guess it. But the mechanism in the law is very weak. It's basically just optional for Congress to abide by or not abide by what the states have done under the text of the act. And so that provides an opening for some of the problems in the objection process that
this is the so-called safe harbor.
Right, exactly. Referred to as a safe harbor provision because if
not
a
all
state
that safe is what you're saying.
Yeah. Right.
Then I've heard reference to the Section 2 part of this whole problem. So somebody lay that out for us as well.
Sure, right, and this refers to a scenario that has not happened but became very close to in 2020. So the law, so the Constitution gives Congress the authority to set the date of a presidential election, and Congress has done that. As we all know, it's the first Tuesday after the first Monday in November. The Electoral Count Act says that if a state has an election on that date and, quote, fails to make a choice, that's the key language there, on election day, then the state can have sort of post-election day procedures as determined by state law to determine the winner of its electoral votes. That phrase, fail to make a choice, the meaning of that, it sounds archaic, it's hard to understand what it means. And the meaning of it, although we'll talk more about this later, like historically was known, it's really been lost to the mists of time. And so it provides ambiguity and misunderstanding that caused real problems in 2020 and led to some efforts to sort of take back election day results under this provision that weren't permissible, but that really should never even gotten as far as they did if the law were clear.
This is basically the scenario where the legislature of a state decides we don't think we had a real election, we had a failed election, and we're going to decide who really won the state. And it doesn't happen to be the person that had the most votes on election day, but for whatever reason, we're going to take over that process of naming the electors for our state, which the concern, I think, is that the failed election language gives that at least a flimsy but altogether too real basis for that to happen. So that's, I think, pretty good summary of all the flaws that people have mostly pointed to. I'm sure there are others. But let me ask you this, Genevieve. Are these problems things that resulted from just a bad legislative drafting back in 1887, or is this because things have changed so much that our system no longer matches the law that they passed?
So I think, Paul, the answer to that is yes. It's a bit of both, right? It's an old law. It's been hardly updated in 130 some odd years. Elections are very different. Adav pointed to one example. My state of Massachusetts had runoff elections, back then, and so the structure of elections was different. The technology was different. the language that we use to describe elections and our laws generally is very different. That said, there were also some questions that the Congress that spent actually 10 years coming up with the ECA just left unresolved or answered in what even at the time was pretty muddled language. So it's a bit of a mixed bag. And, in many respects, we're lucky to have sort of gotten as far as we have with the statute as written. But we learned pretty clearly in the last election that it's time to update the statute.
Certainly true that there are some legal scholars out there who have made their careers by writing 300-page law review articles about all the ambiguities in the statute that fortunately we haven't had to resolve so far, but we could.
Okay.
And so let's get to the meat of the problem here and have all of you talk a little bit about how you would fix it if you were in charge of the world here and could just rewrite the law yourselves. Maybe start with Adav on this one. What addressing the kinds of flaws we've talked about, how should Congress actually go about fixing it? What are the most important things that you would change, and how would you change them?
Yeah, and so I think, if you look at the problems that the panelists here have identified, there's 5 or 6 sort of big ticket items that really need to get fixed for the security of our elections going forward. I'll touch on a couple, and I think
we can pass the baton after that. Okay.
Yeah. So I'll start with the one that I mentioned last, which is this issue of states that fail to make a choice, or the situation where an election essentially isn't concluded on election day, and what happens. There were efforts in 2020 to exploit that language to have state legislatures step in and just unilaterally appoint a state's members of the Electoral College, just overrule the election and decide it at the state legislative level. And that's, if that happens, that's not a democracy anymore. We're not having presidential elections at that point. It's very dangerous for the system, to put it mildly. And it all hinges on this archaic language that was supposed to refer to states that had runoff elections, or to things like, a snowstorm. If there's a snowstorm in 1880 and in a state, that could seriously affect a lot of people's ability to vote. So, as to runoffs, we don't need that anymore. No state has had presidential runoffs in a long time. And if they did, they could use instant runoff voting. There'd be no need to have a whole separate process. We probably do need something in the law that accounts for the possibility that there could be a natural disaster, or an act of war, or a terrorist attack, something that could happen on election day or right before election day that could materially disrupt the election to a point that we would need to have some remedy afterwards. But that could be very specifically defined, right? The law can and should, this is probably, to my mind, this is the top thing Congress should do, is fix this language in the Electoral Count Act to say, if there's a natural disaster or something like an act of war, and it materially disrupts the election in a state so much that it could have affected the outcome, then the state can continue its election past election day as necessary to remedy that problem. Period. Right? And specify that state legislatures don't get to step in and just appoint their electors because they think something went wrong on election day. So it doesn't take a lot of text to do that, but it's probably the top priority, I think, in my mind, for Congress to fix. So that's one. And then the other one that I would mention is the Paul, what you called it the safe harbor provision, and it's become known as the safe harbor provision. This part of the Electoral Count Act that says that if a state follows certain procedures by a certain date to figure out who won its election, then Congress can't second guess that. And as I mentioned, as written, that provision is very weak. It doesn't actually require Congress to do anything. And we saw in practice this last election that states that completely complied with the safe harbor provision in every way still got second guessed, and they still had objections raised in Congress, and Congress still had to vote on whether to accept those electoral results. So that provision, the idea behind it is very good. Incentivizing states to be the ones who resolve their elections is right. But we need a way to give that some teeth and to make sure also that when the states resolve their disputes, they're doing it legally, right? Because you don't want to have a situation where a state resolves its dispute in an illegal or unconstitutional way, and then Congress is just sort of stuck with the result. And I think probably the best way to do this is to build in a process where states get the first crack at it, and they have a deadline by which to resolve any disputes. And then if that's unsatisfactory, or if there continues to be a legitimate dispute about whether that state level resolution was lawful, then the candidates have an option to go to federal court and say, I think the state violated the law or violated the Constitution, have a quick proceeding and resolve the question once and for all, so that when the votes eventually get to Congress, they are the ones that have been found to be lawful by the courts, and there's no further role for Congress to be second guessing.
Just in that regard, I know that there were a lot of people in the last year or so who pointed out that the date for the safe harbor, which last time was, I think, the 14th of December, didn't give the states a lot of time to just go through their routine processes of recounts and emergency appeals to the state Supreme Court and all the stuff they had to get done in order to take advantage of the safe harbor. And in some states, Wisconsin certainly was one, didn't actually get done in time. Would you move the date back some and to create more space?
Yeah, among the other problems with the Electoral Count Act that we're not talking about today is that it was written at a time where all this stuff happened by Pony Express, basically. All these pieces of paper getting carried around on horseback, and so there are very long lead times built into the act for how long it takes to send the votes to Congress and to assemble them in Washington D.C. None of that is needed today, so you don't need that extra time on the back end. You can certainly push back the safe harbor date, push back the date on which the Electoral College voters vote, to give more time for dispute resolution, and then have less for the pieces of paper to move around.
Right. Who wants to take another fix here?
I'm happy to jump in, Paul.
Okay.
So I think next on the list of I think Adav called them the big ticket items, is one we identified earlier, which is the role of the vice president, right? So the 12th Amendment provides that the president of the Senate, who is usually the vice president, right, opens the certificates of electoral votes in front of the House of Representatives and the Senate, and then those votes shall be counted. It says nothing else about that person's role. The Electoral Count Act goes further, and it identifies the vice president as the presiding officer, and it spells out certain duties, preserving order, calling for objections, and ultimately announcing the results. Nowhere in either the 12th Amendment or current law is the vice president given the authority to resolve disputes or decide the outcome of the election. Nonetheless, we have a statute that is, there's any number of adjectives you could use to describe it. It's difficultly written, and we saw arguments made in late 2020 and January 2021 that suggested that the vice president's role should in fact be more substantive. I think those were wrong, but nonetheless, the statute could really benefit from some updating. So I would put on the list making very clear what the role of the vice president as president of the Senate is and is not, and just in being sort of exhaustive about what those obligations and authorities are. And they should be narrow and limited to a largely ceremonial role. Second, this issue of objections, and as you can hear as we talk through these, a lot of these things are sort of intertwined and how they work together to sort of form a coherent whole. So on the issue of objections, there are sort of two pieces to that. One is, as Tommy mentioned, it's quite easy under current law for Congress to raise objections to a state's votes, right? It only takes one member of each chamber to put something in writing, and then that forces a process where the chambers split, debate, and vote on that objection. That's pretty low threshold. So that really should be raised to a more substantial portion of both chambers, somewhere between 1/5 and 1/3, in that ballpark. But in addition to that sort of process, I would add that I think it really needs to be clear what are appropriate grounds for objection. So again, Tommy mentioned that right now the language of the statute sort of has two categories of potential objections. One is whether or not appointments of electors are sort of lawfully certified. The other is whether electoral votes are regularly given. And those words aren't described. Regularly given in particular doesn't have meaning really anymore today, at least. So I think it's important in an updated statute that the appropriate grounds for objection be enumerated and be really narrow. So, and when it comes to appointing electors, it really gets back to the issues that both Adav and Tommy have highlighted, that it's not for Congress to second guess how states conducted their elections, but there should be narrow grounds for objections if the votes that are submitted to them are inauthentic or really unlawful in some way. And then with respect to specific votes, right, the votes actually cast by the electors once they're appointed, again, a narrow list of grounds for objection that really are tied to strict constitutional or statutory requirements. And that should be about it.
Is there a final sort of issue to talk about, which is what do we do if we have a Congress that can't agree on what the right answer is, even with all the guidance we'd be giving them with this new statute?
I think that's right. You know, if all of these other fixes are made, it should be much less likely that we reach that sort of ultimate, sort of precipice of constitutional crisis. But it's not. I think it's not entirely impossible. And so having, at a minimum, very clear, unambiguous rules of decision as to what happens in various circumstances. If that process I mentioned, where the chambers split and vote on objection, and they disagree, what then happens? Which votes are counted or not counted, or which prevail? That should be. We're talking then about the outcome of a presidential election is the last place you want there to be ambiguity in the law, and so that really should be, at a minimum, there should be very clear rules. There are potentially other mechanisms, but I think that's the minimum. And then, I think I'm going to actually pass it off to Tommy. There are some other things that I think are worth considering. And, one of them involves math. So very happy to pass it on to Tommy to talk about.
Sure, happy to. I was just going to also quickly follow on what you were discussing about ambiguity and sort of tiebreakers and such. In my view, one of the biggest reforms that needs to happen is getting rid of what's called the so-called governor's tiebreaker, that basically says if multiple returns are submitted and the House and Senate disagree on which one is legitimate, then you just go with whichever one was certified by the governor, even if that goes against court orders, popular vote, what have you. So in my view, I would get rid of the whole paradigm of thinking about multiple returns being submitted. It's ambiguous about what qualifies as a return to sort of make multiple returns. Is it anything mailed in by any office holder in the state? I would create clear rules that sort of make one presumptive return to be voted on by Congress to either accept it or reject it. And maybe the governor's seal could start by making it presumptive, but say a court order could get rid of that presumption that it's the return if a court says no, the governor has gone rogue in this situation. So basically just a series of steps to identify the presumptive legitimate return from the state, rather than just dumping a bunch on Congress and saying you decide which one. The math question that was raised, this is a rule in the 12th Amendment that's come up a couple times. It's happened a couple times. It says if no presidential candidate wins a majority of the whole number of electors appointed, then you go to a contingent election in the House. Each state delegation counts as one equal vote. So you can have some weird outcomes, some potentially anti-democratic outcomes going against who won either the plurality of electors or a plurality of the popular vote. The ambiguity is, if a vote is tossed out, does that lower the whole number of electors appointed, the so-called denominator, if you're doing the divisor math? The Electoral Count Act says nothing about that, so that needs to be clarified. I think a consensus that's starting to emerge is that if you toss out an appointment of an elector, so if a state really did fail to have, if a state,
failed to vote,
doesn't have an election, if it goes rogue, if there's a civil war happening, or if someone perhaps wasn't constitutionally eligible to elector, then there's no appointment and you do lower the whole number of electors appointed. Whereas if there's something wrong with the vote that they cast it on the wrong day, for example, then maybe you're tossing out that vote, but you still treat it as an appointment, so the denominator doesn't change. People can legitimately debate what the best rule is, but again, you need to clarify that. Another thing that needs to be clarified, another change that's happened since 1887, we had the 20th Amendment and new rules for succession. What happens if the winning candidate dies before inauguration day? The 20th Amendment says you inaugurate the running mate, the vice president-elect, which makes sense from a democratic point of view. Problem is, under the Electoral Count Act as currently written, it's arguably allowable to toss out votes for a deceased candidate, and that can actually have an anti-democratic outcome. If you toss out all the votes for the deceased candidate, you elect the losing party's presidential candidate by default. So I think it needs to be clarified to comport with the 20th Amendment succession rules and say you count the votes, but you declare that the person who's won a majority has died or is ineligible, and you make clear that the running mate of that person will be inaugurated. So these are kind of the wonky details, some of which have occurred because of changes.
But let me ask one final question about all of this. We did talk about this problem of the House and Senate in a deadlock, each picking a different person, and the need to have a resolution for that. Are at least some people think the way to do that is to turn it over to the Supreme Court by statute. Is that something you would support?
I think you can have Supreme Court litigation before the electoral count date, but I'm personally skeptical. Other panelists may disagree. I'm personally skeptical of a procedure after it reaches Congress. I think that the Constitution, as vague as it is, it does. I think it indicates that you're supposed to make a call at that meeting of the electors. It says the votes shall then be counted. So I would prefer a procedure where all of the fact-finding or legal issues or disputes are handled before you get to that date rather than after it.
Any other views?
I'll jump quickly. So I agree with Tommy in that I would prefer that, certainly. I think there may be a little bit of a sort of just practical inevitability that in the kind of, nightmare scenario you're describing, that there will in fact be litigation, and there may be some value to clarifying how that proceeds. But at a minimum, like I said, there's more than one mechanism. But what happens at that stage, if we were to actually reach it, should be absolutely clear. There are potentially other mechanisms in addition to just clear rules of decision that Congress might consider. But I do think that the courts is likely to be involved one way or the other.
That does seem like where it would end up if there really is no other answer, but not necessarily the ideal way to go. Let me ask you this question, Tommy. I mean, we have. It seems clear, just looking at the way things are moving on the Hill, people from both sides of the aisle who are interested in updating the Electoral Count Act, and there are some proposals. One here is floating around up there, but there are also some people on both sides of the aisle who raise concerns, seem nervous about, hesitant about updating something that goes to such a core part of our election process. What would you say to them about why this is the right time to do something significant to fix these problems?
Yeah, so there are a few different types of objections. One I've focused on is that some have said the whole Electoral Count Act scheme is unconstitutional and always has been, and that if it's unconstitutional, you don't want to update it and further entrench a law that was unconstitutional to begin with. They basically say, look, how is it that Congress could possibly have the power to toss out electors appointed by the states? It's up to the states to decide the manner of election. I don't agree with those arguments. I think as vague as the Constitution is, it does put in that joint session of Congress the power to, again, the votes shall then be counted. That's what it says. So I kind of analogize that vague language to like the State of the Union address. The Constitution is very vague about how the president delivers the State of the Union: in person, letter, what day, what time. It gives Congress power to fill in the details of how that works. I think the electoral count is similar in that way. There are all of these details we're debating, threshold, etc. None of those are required by the Constitution, but I also think that means none of those are unconstitutional. It's discretionary. I think others have objected that this is all better put in the court system. Again, similar to what we were just saying, bypass Congress entirely and just go straight to the Supreme Court to decide which is the ideal one to count. Again, I think the Constitution indicates that the framers chose a different role and an understandable role, in the sense that this is the joint session is one period where you have every politically accountable member of essentially two branches of government joined together. And I think there's value in this demonstration of hopefully consensus and legitimate transfer of power at that joint session. So I don't think Congress is abrogating too much power to itself to make what should be small, reasonable decisions about, is this a valid vote to be counted or not.
Adav, Genevieve, do you have anything to add to that? Other things you would say to reassure people about how it's okay to sort of venture in this way?
Yeah, I mean, one of the other hesitations that one hears about this is that, well, the Electoral Count Act is all that only starts at election day and goes afterwards, right? If we're trying to protect the democratic system, you know, there have been efforts, and there are right now efforts underway to sort of create problems before election day, right? To skew rules or procedures so that the problems of the election occur in the casting of the popular vote, not in the casting of the electoral vote. And so, sort of like, what good does it do to fix the Electoral Count Act if by the time you get to election day, all the problems are already baked into the system? And there's some truth to that, and that's why, you know, like, we Campaign Legal Center has devoted tremendous time and resources to trying to prevent some of those efforts to create problems on the front end. But we need both, right? We need to protect both sides of the system, both the front end and the back end, right? We need to have fair casting of votes, but also fair counting of votes, and particularly in the presidential election, where there's this additional step of the electoral vote. All of that needs to be secure for our democracy to withstand efforts to tamper with it that we have seen, and I think we're going to continue to see.
All right. Well, I guess then maybe the $10,000 question is, we've just scared everybody that we have this terrible system that could go crash and burn 6 times along the way, and there are people out there who might want to make that happen in certain electoral situations in 2024 that are foreseeable. What is the likelihood? Maybe start with Genevieve on this one. You can all make your preseason predictions here. What's the likelihood that Congress, having failed to do anything else in election reform this past year, is actually going to jump in and actually get this done?
Yeah, so I'm not a gambler, but I am feeling, I think, quite cautiously optimistic. I'm also feeling a lot of urgency. So I think time will tell, but that time is relatively short. What we are seeing.
What is the time frame for when this really practically has to happen in your view?
In my view, it's this year is the best opportunity, and there's a few reasons for that. There's a lot of momentum, both I think on the Hill and off the Hill. There's a lot of consensus. You can see a bit on this call, and if you sort of poke around, you can see on our website and others that really folks across the ideological spectrum agree not only that the statute should be updated, but really agree on a lot of the parameters of how. There's public polling showing that your average American now, once they begin to understand the statute a bit, also
they know what it is, right? Yeah.
Once they know what it is, and that it exists and what it is. And there's a decent-sized bipartisan group of senators digging into this, and they have been for several months. Like I said, time will tell, but there's an effort underway, and I think that's more than we can say in some other areas of policy or legislation making.
Well, yeah. It has the advantage that both Senator Schumer and Senator McConnell could be supporters, and that makes it at least possible. What do you think, Adav, Tommy? Are we going to get there this year?
I'm cautiously optimistic. I mean, in 2022, it's always a little bit risky to say I think Congress is going to do something. But I think this has better odds than most. I mean, there are a lot of motivations going on, but as I think we've all touched on, January 6th is one of them. And remember, these are the same people who were physically chased out of their workplace by a violent mob. They have not forgotten that. And it was all based on, not all, but it was largely based on misunderstandings and misrepresentations about this law that we're talking about these very provisions. And so I think there is a real sense that Congress doesn't want to be in that position again, that the partisan effects of this are neutral. These fixes that we've talked about today benefit no party over the other, and that they would be good for the nation. So I think there is a real chance, and real conversations are happening now to try to make it happen.
Tommy, are you in touch with the Hill enough to have a prediction here?
Tough to say. I echo what the other panelists have said, that I think I see bipartisan interest, at least from people we've talked to. I'll add that a pitch that I make to Republicans, and that I've heard many Republicans agree with, there's correlation to some extent. Those on the right often tend to be more fans of the Electoral College, or at least more interested in making sure that we keep that going. I know that's somewhat of a controversial issue, but what I say is, look, if you're interested in the Electoral College continuing to be our system, you should have a strong interest in the procedure for the Electoral College being as secure and as foolproof as possible. And the more people get the impression that this is a system held together with sticky tape and super glue, and that it could easily fall apart at the last minute, the more people are going to say, well, maybe we should just toss out the whole thing and go to a straightforward, national popular vote. And so that's just another reason why this should be at least a bipartisan interest in getting rid of any possible loopholes or ways to cheat the system.
Thanks. Well, that really makes sense. Let me see whether or not we're about at time for the Q&A, whether there are questions that are going to pop up here that we can chew on here. Okay, first question, Michael Morency. I appreciate all the points made by the participants. However, practically speaking, is it realistic to think that the act could be updated in a manner that the participants would find reasonable? But are we being unrealistic?
I mean, I can start.
Yourselves here. Come on.
I think the answer is a bit the same, to the extent that we have insights into what members of Congress were thinking about in terms of the substance. It's aligned with what we've been talking about today. And that's, like I said, consistent with a sort of consensus off the Hill across ideologies on what needs to be fixed and sort of, in many respects at least, how. So I don't think it's unrealistic, but we shall see.
Yeah, I agree. And, fundamentally, I don't think you would find a couple of sort of grandstanders aside. I don't think you would find many people in Congress who actually think that Congress should sit as some sort of national election board every 4 years to determine who the next president is. I mean, it's put aside the legalities for a second. Like, that's ridiculous. That is a ridiculous proposition. And I don't think, for the reasons we've talked about, I don't think it's really a position that most members of Congress want to be in, recognizing there are some vocal ones who might feel differently. But, it may well be that the incentives of that larger majority win out, and we do get some legislation that essentially cabins the ability of the more strident minority to co-opt or grandstand within the system.
Great. Go ahead, Tommy.
Yeah, I'll just add, I don't think the fact that, again, this law hasn't been changed since 1887, I don't think people should read into that, it's clearly it's entrenched and impossible to change, and any change would be super controversial. The fact is, people only pay attention to this law when we have contested elections and things go wrong. Basically, the last two times it's had attention were 2000 and 2020. And so, yes, we had the whole 20th century, but we actually were pretty lucky throughout the whole 20th century that we never really had much electoral count disputes. One minor one in 1960 that didn't affect the outcome. And so I think we're actually, as old as this law is, we're actually pretty early in the scholarship and efforts to think about all of its flaws, just because we haven't had to think about them very much.
Okay, another question? Are there viable bills in Congress to do some of these things? What can we talk about with respect to the actual proposals that are up on the Hill?
I'm happy to start. So there are, in terms of bills, I think that the question used the word bills. I don't believe there are any bills.
How's that?
Yeah, well, I mean, just so I don't think there are any bills per se, right? I don't believe any members of Congress have introduced legislation say here's a bill. There is an extensive draft that was put out by three senators Klobuchar, King, and Durbin, to fix many of the problems that we're talking about today. And it's been widely reported that there's a group of about 16 to 18 senators who are discussing amongst themselves, bipartisan group, evenly divided between Democrats and Republicans, discussing among themselves the specifics of reform and trying to come up with that legislation. And then it's also been pretty widely reported that on the House side, Representatives Lofgren and Raskin, who are the leaders of the House committee that has jurisdiction over these issues, have taken significant interest in trying to devise solutions. So there's not a bill yet, but clearly there are folks actively working on it.
And the bill we've seen from the three senators that you mentioned, is it your assessment that would pretty well address the kinds of problems we've talked about in the ways we've talked about?
Yeah, I mean, it was labeled, it was released by the senators and labeled a discussion draft. And so I think it's intended to start discussions and has been successful in that respect. And we'll see, whether the resolutions proposed there are the ones that end up being of interest, or they get revised, or some other approach gets taken.
Yeah, I'll add, we've blogged about it a bit at Cato. It definitely hits a lot of the reforms we've talked to. I think the biggest controversy is whether it perhaps creates too many causes of actions, that it gets pretty complicated in terms of the various ways you can go into court. So these are kinds of the details that hopefully don't end up being a roadblock to reform, but that still need to be debated, and the details where you might have to work things out and have some disagreement along the way.
Anything to add, Genevieve?
No, I think that's all right. I mean, in terms of, the way we're looking at the way the discussion is unfolding in drafts that are being released, is sort of, does it sort of check all the 5 or 6 boxes of the key sort of things, the big ticket items that really should be addressed, and that draft does. And there's maybe some work to do around exactly some of the details, but I think it shows at least that it can be done.
Right. I mean, it seems like this issue of judicial review is going to be among the more controversial, because some people in Congress are going to say maybe Congress is the right place rather than the courts, and others will disagree. It seems like we may see how that plays out over the whole rest of the year. Is there another question? Stephen Spitz, Congress should not be allowed to second guess the popular vote. Certainly nor should state legislatures. Why not why shouldn't we just have direct election of the president by the people? Tommy, I know what you seem to have a view on this. You want to start with that?
I've sort of, even in my career, I would say in college and law school, I was a pretty big fan, actually, at one time, of like a national popular vote compact. The more I've worked, the more skeptical I've become. I would say one thing that's just, and this is probably controversial on this panel, a lot of the co-panelists may disagree, the one thing people don't pay enough attention to is the fact that we have 50 different suffrage rules in 50 different states. And so we're kind of unusual in that way. Most big countries that have popular votes just have one national rule for who's eligible to vote. So if you had a national popular vote, states would be incentivized to essentially enfranchise more and more people. Whether that's a good or a bad thing is itself controversial, but it needs to be at least confronted. The fact that, back in the 19th century, you had differences in which states women could vote in or not. And it was just when the popular vote was discussed, states where women could not vote complained that, hey, they're basically going to get twice as many votes as we do. There aren't as many big differences now, but there are still some differences. So I think you could only really have a fair national popular vote if you also had one nationwide standard for eligibility to vote, and that itself would be an extremely controversial change from the federalist system we've had.
Probably would. You mentioned before that maybe people on the right tend to be more pro-electoral college. You think that's just directly tied to the way that it's operated in the 2000 and the 2016 elections?
There are a lot of factors. I mean, one is just sort of the notion that it's more federalist, again, that it gives states more freedom to decide to run their own elections. In theory, it gives them the freedom to even not have a popular election. States could go to other systems, or states could choose to have a runoff or not have a runoff, or give all of their electoral votes to one winner, or split them like Maine and Nebraska do. So I think it's mostly just a skepticism of one's top-down rule for the whole country, and a preference to let states experiment with rules of suffrage, rules of election conduct, and so on. But again, as with the major caveat that all of the baseline constitutional rights, like equal protection, are limitations on the discretion that states have in how they choose their electors.
Adav, Genevieve?
Yeah, I just, just to bring us back a little bit to the Electoral Count Act, I think there's an interesting debate to be had about popular vote versus electoral college. But of course, what we're talking about there is a major constitutional change. And so, it doesn't change the sort of analysis in the short term. We have an immediate problem with the statute that governs presidential elections that we now know is seriously flawed, and we face real risks going into the next presidential election and thereafter. So I think you can have that debate while also saying that this law needs to be fixed, and it needs to be fixed pretty urgently.
Okay, is there another question? Not seeing one. Okay, let's then move toward winding up this, I think, been terrific discussion. Do you guys each want to give us a little sort of final benediction about this topic and what you would like us all to know about it?
Well, maybe I'll start where I just left off. That was a little bit of my final my final words, just emphasizing that there really is an urgency here. It's difficult work, but there is an urgency here now, and we're really in the best time frame to do this, building on momentum and consensus, and so far ahead of the 2024 election before the political landscape has taken shape. And then I would just emphasize that I think what's really come out of this discussion is the need for Congress to really get into the details and address the various parts of the statute. And it may be tempting to sort of grab onto some low-hanging fruit, but I hope that Congress will really delve in and address it in a sort of wholesome way.
A partial fix does not seem like the desirable outcome. It doesn't really fix it.
Right.
Adav?
Sure, and I would say, it's interesting because, and we hear this a lot, and the questions today sort of reflect it. There's pretty broad, like actually exceptionally broad agreement that there are problems here, about what the problems are, and even in many ways about what the fixes are. And the questions tend to be like, yeah, but is it realistic? Yeah, but is it going to happen? Right? And I think obviously we all understand where those questions are coming from, given the sort of state of the dysfunction in Congress. But there is real hope here, and all of us can play a role in helping to move this, right? I mean, if there were just a half notch more sort of public attention to this, and folks saying like, yes, members of Congress, like, you'd be doing the right thing by protecting our elections going forward, that could make a real difference, because there are members of Congress who want to do it, and they're just waiting to see, is this going to help me or hurt me? And it's not, I think, realistically going to hurt anybody. So just a little bit more sort of in the public sphere about like the interest of keeping our nation safe in this respect would be helpful, and can help make this happen.
Definitely. Yeah, I echo all of that. I think now is the time to do it. One way you might think of it is we're in the farther away from the election we are, the more we're in the veil of ignorance. So no party knows that any given rule is going to help them. And of course, as we've seen, it's been since 1887 since we had our last law. So hopefully these changes don't happen very often. So we would want to write one that would work for the next 100 years. And obviously you can't predict which is going to benefit one party or the other over a 100-year time span. So what we want is consensus on just the best rules, period, not the best rules to help any given party. And there should be consensus. Again, everybody wants the legitimate winner of their state to be decided in a by rules set out well in advance, starting with the court system 99.9% of the time for any fact-finding issue. So I think, again, there's a misconception that if you have any Electoral Count Act, that's too big of a window for Congress to potentially toss out votes. So I think it's good for people to learn that no, what these reforms would do would really narrow them to extremely unlikely scenarios where people, electors have really just acted lawlessly, or they've just violated clear, explicit rules in the Constitution, like you can't vote for a president and vice president from your home state, things that are just very unlikely to happen, period. And if we have those rules set out crystal clear in advance, people will know, okay, the way to deal with objections to how an election was conducted are in the courts, not on January 6th as like a backup court.
Thanks for that. Let me just sum things up a little bit here, and then we'll thank you all and end this wonderful discussion. The next presidential election could be one of the most contentious ever, and the flaws in the ECA, which hasn't been updated, as we've discussed, could allow the majority party in Congress to throw out a state's certified election results. Over 60% of the voters across partisan, demographic, and geographic lines support updating the ECA. It really needs to be updated to protect the will of the people from those in Congress who might want to stay in power, because elections should be decided by voters, not partisan politicians. And for all the other reasons which our panelists so ably discussed, it does need to be done, and 2022 is the time for it to happen. If you have additional questions or would like more information, please email us at info@campaignlegalcenter.org. Thank you again and have a great afternoon. And thanks again to our wonderful panel and to all of you for joining us today. Take care, everybody.